So again, good evening, everyone. Welcome. In collaboration with the Department of Labor, the Kansas State Conference of NAACP branches presents Understanding Wage and Hour Laws. The Wage and Hour Division of the Department of Labor's mission is simply to promote and achieve compliance with labor standards to protect and enhance the welfare of the nation's workforce. Understanding the critical changes and aspects of wage and hour law is simply essential, not just for the Kansas NAACP, but you as an employee, as well as a practitioner. This training tonight is designed for any employee or practitioner at every single level. That means all knowledge levels, private and public sector. Our guest speaker for tonight is Ms. Trini Mergua. Trini has been with the U.S. Department of Labor Wage and Hour Division since 2009. She spent 9 years as an investigator, investigating hundreds of cases under several laws, including the Fair Labor Standards Act, the Davis-Bacon Act, H-2A, and the Family Medical Leave Act. Over the past 3.5 years, Trini has served as the Community Outreach and Resource Planning Specialist in the Kansas City District Office, specifically Wage and Hour. In this capacity, Trini spends most of her time organizing and conducting DOL educational and training events like the one tonight. She does this throughout the states of Kansas and the western region of Missouri. So, ladies and gentlemen, please welcome Trini.
Good evening, everyone. Thank you, TJ, for that introduction. I am so happy to be here with you all this evening, and I'm excited to share more information about the Wage and Hour Division, and for you to walk away with a little bit of more knowledge, and know that in this capacity, I don't expect you all to be experts. I definitely don't want you to have to memorize everything. Please be aware that I am at your disposal. If you have any questions, you can email me, reach out to me. But we also have several investigators, technicians on the phones every single day from 8 a.m. to 4:30. And we have many options as far as languages, if that's a concern, but they are available anytime to answer any questions that you may have. Now, TJ is going to share a resource guide with you all. This has so much information in it. It can be a little overwhelming, but please, again, it goes along with the presentation that I'm about to share with you all. You'll have this resource for future if you have any questions regarding the Wage and Hour Division, and it gives great examples. It goes through all the key terminology that I'll be speaking about tonight, and I'll also be referencing in my presentation where you can find what we're talking about as I'm going through the presentation. Okay, I'll go ahead and share my presentation. Can everybody see it?
Yes.
Okay, perfect. All right. So this is a presentation that I love to give to organizations, advocacy groups, people who are in contact with vulnerable workers who are on the front lines, and that I'm not able to get to necessarily every single day. You all are kind of our lifeline when it comes to sharing this information and making sure that people are knowledgeable about the rights when it comes to the hours worked and their pay. A lot of people don't realize what their rights are. And so that's where you guys come into play, walking away with a little bit of key terms and knowledge about wage and hour, and knowing to say, oh, okay, I think this is where we should send them, or that's definitely a wage and hour question. Let me get you that resource. So again, thank you so much for attending tonight. I appreciate you all being here with me this evening. And we're going to hold questions for the end. So definitely you can put them into the chat group, and I'll have TJ to make sure to let me know about that, but definitely ask as many questions as you can. And if I don't know it, I will definitely get you that information later on. So we ran a huge campaign. It's called Essential Workers, Essential Protections. We wanted to make sure, especially after going through this pandemic, that people knew who Wage and Hour was, that they knew that they are due their wages for all hours worked, that we are able to help them with that. And everything is confidential and free. We're able to go back 2 years. So we started this huge campaign, doing a ton of outreach in person. We're starting to do that a little bit now, but also virtually, like what we're doing tonight. So thank you for being a part of that. So this is my information. This is where our office is located. We just changed offices. So we used to be in Kansas City, Kansas on State Avenue. Now we have moved to KC Mo on Main Street. People are able to come to us and speak with us if they would like. Currently, right now, though, we are not accepting anyone because we are still waiting for furniture in our office. But you can definitely call us. That's our phone number that you can call, that people are always answering from 8 a.m. to 4:30. I also posted our website. I will be giving this presentation to TJ afterwards, and she can share that all with you all. But this is just our contact information. We also have a area office that is in Wichita, Kansas, and another one that is in Springfield, Missouri, as we cover the entire state of Kansas and then the western region of Missouri. Okay, so this is just a disclaimer. Just if you have any questions, reach out to us. Again, these are the laws that we enforce, and we don't expect you guys to be experts in this field. Now, also realize we are the Federal Department of Labor. There are state Department of Labors, and they are different. The laws are a little bit different. So because we cover Kansas and Missouri, Missouri's minimum wage currently right now is $11.15, and our federal minimum wage is different than that. So we wouldn't be able to enforce that except for possibly in overtime weeks. The state of Kansas is $7.25 an hour, and overtime, some examples of things that are a little bit different from our law is that the state of Kansas, overtime is after 46 hours. Obviously, we enforce it after 40 hours. And they also facilitate as far as if you work so many hours, you have to get so many breaks. Where my agency with the Federal Department of Labor, we don't have those types of laws. So that's just to kind of explain that there might be laws that are a little bit different from the Federal Department of Labor. Okay, so Wage and Hour Division will enforce the law without regard to an employee's immigration status. So no employer should have an unfair advantage because he employs undocumented employees, and he doesn't pay them. So we will enforce hours worked, whether they are a U.S. citizen or not, okay? Everyone is due their wages for the work that they were doing, okay? The Wage Hour Division is a multilingual organization, and so we're able to help many callers with more than 200 languages. So just be aware that we do have different resources to speak with people if they don't speak English. So we are focusing on low wage, vulnerable, essential workers in industries where data and evidence has shown us that violations are high, yet complaints are very low. And so the laws we enforce to protect the workforce include those listed on this slide, each providing unique rights and protections. So can people put in the chat group, can you put what the minimum wage is right now for Federal Department of Labor? I'm just curious if people know. And I can't see the chat, TJ, so.
No one's put anything in. So down at the bottom, do you see the chat button?
Oh, yeah, I see it now.
Yeah. So you've got a couple messages coming. So one person said $15. Someone said
wish.
25.
Okay. We'll let a couple more people. Okay. So currently the federal minimum wage is $7.25 an hour. So remember how I said the state of Missouri is a little bit different because they have a higher minimum wage. It's been going up every year. For the Federal Department of Labor, what we enforce is $7.25 an hour. Okay. And it has not changed since 2009. So these just kind of go into other things that we enforce, and we'll go into detail about these. So who is protected? Most employees, most enterprises, and all work weeks are protected. There are some individual employees of smaller businesses that are protected on a work week basis. And then we have named enterprises. So a long, long time ago, they incorporated these named enterprises. So you don't have to meet the criteria where other businesses have to meet certain criteria to be protected under our law. And so these include like your hospitals, your schools, daycares, preschools, residential living centers, and nursing homes. Those are all automatically protected under our law, no matter if they meet a certain threshold as far as ADV is concerned, or if how many employees they have. They will always be under our jurisdiction. Domestic employees such as housekeepers or full-time babysitters are protected under our laws. The FLSA requires payment of the current federal minimum wage of $7.25 an hour, payment of overtime at a time of 1.5 of a worker's regular rate of pay for hours over 40 hours in a work week. So we also require accurate record keeping for employees, including a breakdown of like their daily hours, wages paid, any deductions that are made. Those are all things that we're going to be looking at on a work week basis when we're trying to see, is there a violation of minimum wage? Is there a violation of overtime? We also do protections for young workers under the child labor portion of the act. What the FLSA does not require is like your vacation, your holiday, severance or sick pay, meal or rest periods. I know that's a shocker, but we do not have anything in our law that says that that an employer or a business has to give you so much time for a lunch break, or if you work so many hours, the 15-minute break. We do not enforce that. Now, each state is different, so the state might be able to enforce that. You'll definitely want to look into your local laws. So in your Aware resource book, if you're able to open it up while I'm doing this presentation, it's on page 8 that we're going to be talking about work week, and it discusses work week a little bit more in detail. Again, you'll be able to get these resources afterwards. So we're looking at a work week, 7 consecutive days. The employer or the business gets to decide when that starts and when that ends. So it could be starting on a Monday, ending on a Sunday. It could start on a Wednesday and ending on a Tuesday. So they get to determine what that work week looks like. And then we're able to go in and look at that work week and make sure, are you paying minimum wage? Are you paying overtime? And looking at those documents to make sure that the employer is in compliance with the Fair Labor Standards Act. Again, this is the gross weekly straight time pay. This is on page 9, and it gives examples that you can review. So gross weekly straight time pay is all of the workers' pay before any deductions are taken, including all extra payments such as production bonuses, commissions, tip credits, or any other pay that employee receives. So it's your total pay for the entire week. It does not include any premiums paid for overtime. In many cases where employees' hours vary, gross weekly straight time pay is different from week to week. So depending on how you're paid, you could have one week where you're receiving more than what you normally receive the week before. So it fluctuates. Again, this is on page 9 of your Aware resource book, but it talks about how do you come up with an hourly rate. And so we get this question all the time, and here's a perfect example of how you would calculate that. In the resource book, it also gives you different examples of different scenarios, but the regular rate, which is used to determine whether a worker has been paid at least minimum wage for all the hours they have worked, is also used to calculate the proper overtime rate. So it's determined by dividing the gross weekly straight time pay by the total number of hours worked in that week. Gross weekly straight time pay is all of the workers' pay before any deductions are taken, and that includes what we had discussed before, your bonuses, your commissions, tip credits, any other pay the employer receives. So wages may be earned on an hourly or a piece rate or by a salary, commission, some other basis. Those are all options that an employer or a business can choose how to pay their employees. We also have a great fact sheet that I will give to TJ. It's our fact sheet 23, and it's overtime pay requirements of the Fair Labor Standards Act. I'll also include our website so that you guys have that resource as well. And we have some great fact sheets that are specific to different industries, as well as what laws we enforce. And they're just a better read than actually going through the law itself. The regular rate of pay cannot legally be below minimum wage. So if your calculations show that a worker's rate is less than minimum wage, $7.25, there might be a wage and hour violation. The regular rate includes all remuneration for employment, except certain payments excluded by the act itself. So payments which are not part of the regular rate include pay for expenses incurred on the employer's behalf, premium payments for overtime work, or the true premiums paid for work on Saturdays, Sundays, and holidays, discretionary bonuses, gifts, and payments in the nature of gifts on special occasions, and payments for occasional periods when no work is performed due to vacation, holidays, or illness. Again, if you have any questions, please reach out to us. So tipped employees. We constantly get calls about tipped employees and do we get to keep all of our tips? You know, my employer's taking some of my tips. You know, how are we protected? So this is on page 14 of your resource book. If you want to review that, it goes into detail about it. So tipped employees are those who are engaged in an occupation in which they customarily and regularly receive more than $30 a month in tips. So these are your waiters, your bussers, your people who are cleaning the tables afterwards. This could also include your bartenders, people like that, okay? So the law permits an employer to take a tip credit toward its minimum wage obligation for tipped employees equal to the difference between the required cash wage, which must be $2.13. So they must get at least that cash wage when they are a tipped employee. And then the tips, the difference of $5.12, the difference in tips that they're receiving is what brings them up to minimum wage. So an employer can only take the tip credit when it meets certain requirements. If the employer decides to use the tip credit provisions, the employer must pay tipped employees at least $2.13 an hour in direct cash wages, so by check, cash, however they choose they want to pay, before taxes on the payroll. So even if the employee's tips or combination of tips and direct wages exceed $7.25 an hour, okay, so they can be more. We just want to make sure when we're going in and conducting our investigations, we're reviewing the documentation and saying, did they at least receive $5.12 an hour in tips? Hours worked. So this can be found on page 22 of your resource guide, and it talks about hours worked. They are hours worked per day and per work week. So whether or not the employer counts the time as work time, sometimes what we'll see when we're conducting investigations is that there'll be a set schedule, but it's not actually showing us the time that they clock in, the time that they leave for lunch, return from lunch, and then leave for the day. Those are actually the hours worked. And we've also seen a lot of employers who will take the time system information, like if they're clocking in and out or writing down their time, they'll put that into the payroll system and get rid of their time records. We still need to see their time records and make sure that they align with the actual payroll records, okay? Because those can be different, right? So we see a lot of times where that is not happening or they don't have those records. And so that's why we conduct our investigations and talk to employees, conduct our interviews, things like that. So we definitely want to make sure, and it's critical that employers are keeping track of hours worked. Employees need to realize that they should be writing down their time too to see if they're actually receiving minimum wage and overtime. So it's a huge record keeping violation if they do not have this documentation. So covered employees must be paid for all hours worked in a work week. In general, hours worked includes all the time an employee must be on duty or at the employer's premises or at any other prescribed place of work, from the beginning of their first principal activity to the last principal work activity of the workday. Also included is any additional time the employee is allowed, or we call it suffered or permitted to work. So it means hours between the time employee begins work and ends work on a particular day. So like work time could include if you're waiting for repairs for equipment necessary for work. That would be included as hours worked. Time spent traveling between work sites during the workday. You know, you have your construction workers that are going from one site to the next site. You have your landscapers that are working on different homes. People are traveling in between. So all of that is considered hours work. Time spent before or after shift. We see a lot of this where there's a violation where somebody will say, well, I decided to come in early because I didn't get my work done the day before. Well, it's still to be considered hours worked because it's to the employer's benefit that you are working, right? So you should be compensated for that time. So this is your pre and post shift time. Those all need to be included in your hours worked, not just a set schedule of 8 to 4:30 or 8 to 5. We need to see and make sure that you're actually showing the time that you enter and you leave. So minimum wage, of course, is $7.25 an hour. We're going to be testing. We're going to be looking at records, speaking with employees, and just making sure that everything is aligning up and that we're able to see, okay, they did receive at least $7.25 an hour. If you receive less than $7.25 an hour, then you are to be compensated for that. Things that I see that kind of become a violation, let's say the employer is making you have a uniform. Now, what is a uniform? We consider a uniform to be something that you cannot take to another business. So like if it has the logo on it, if it has something specific to that business that you're not able to use it down the road for another job, then that's considered a uniform. And if the employer is requiring you to have a uniform and you're being paid $7.25 an hour, they cannot make a deduction for that uniform expense. If you are making above minimum wage, then they can make that deduction. It just can't bring you below $7.25. Okay, so just got to make sure you're looking at your records, making sure people are paying attention to what's being deducted out of their paycheck. So on page 31, there'll be a flow chart that kind of discusses overtime and what does that look like. But the guidelines for overtime is on page 32 of your resource guide. You must make an accurate determination of the number of hours worked to determine when overtime is due. Okay, so overtime pay is at a rate of time and a half, an employee's regular rate of pay. And it's generally required for any hours worked in excess of 40 hours a week. The FLSA does not limit the number of hours employees 16 years or older can be required to work in a day or a week. So we'll talk a little bit about child labor and time restrictions for 14 and 15-year-olds. So 16 years and above, they can work as many hours, they can work overtime, they just have to be paid for that. Again, state laws might differ a little bit, so make sure you check in with the state. And then there are exemptions, right, from overtime. So we'll talk a little bit about that, exemptions and what does that mean. But again, time and a half after 40 hours. Overtime is not due after 8 hours in a day. Okay, it's only 40 hours in a work week, 7 consecutive days. Anything after that is to be paid at time and a half. And then overtime is not required for work on weekends or holidays. Those are benefits or choices that the employer, the business can give employees, but it is not required. Overtime cannot be taken as compensatory time, so time off. So unless that employee is a state or local government employee, okay? So those are the only employees that can actually take comp time. But if you're working for a public employer, any other type of business, private employers, they cannot offer that instead of overtime. And we do see that where people are banking hours and trying to adjust their payroll records. We see it every single day. Just be aware that you cannot do that unless you're an actual state or local, or you're working for an employer for a state and local government. And then overtime should be recorded separately on the employee's statement of earnings. So on their pay stub, a lot of employers are moving to online. And so I think that's really made it difficult to see if you're actually being paid correctly, because people don't really pay attention to that. So make sure that they're looking at their pay stub, and it should show you if they're working over 40 hours in a week and if they're being paid for overtime. And employees may be due overtime regardless of how they are paid. So if they're paid a salary, commission, hourly, piece rate, overtime could possibly still be in effect for those employees. Tipped employees who work over 40 hours a week are due time and a half of their regular rate of pay for overtime. So their regular rate, including any tip credit taken, must be at least the minimum wage, which is currently $7.25 an hour. So you can look at page 32 through 36 for exemptions. We kind of talked about it a little bit, but the FLSA provides not only for limited exemptions from overtime, but also limited exemptions from minimum wage. So you have your managers, your office workers, and other white collar employees that have to meet a salary and a duties test in order to be exempt from minimum wage and overtime in any given work week. So the ones that we see the most of are your executive employees, your administrative exemptions, and your professional exemptions. So for the administrative, you have to have a salary. It's $684 a week. So it changed just recently. And so it was on January 1st of 2020 when that amount changed to $684 a week. So they have to receive their salary, and then the duties test is for someone who's an administrative exemption. Their primary duty must be of office or non-manual work directly related to management. So they're doing management work. And then it includes they can decide on things of significance for the company. So they could put the company in jeopardy by ultimately having the choice on how they do things, changing company policy, those kinds of things. So it's exercising that discretion and independent judgment. So that's for the administrative. Executive is where we're talking about your bona fide managers. So they still have to meet that salary test of $684 a week that went into effect on January 1st. And a part of that salary that I didn't mention, it can be up to 10% of the minimum salary level may be composed of non-discretionary bonuses, commissions, incentive payments paid on an annual or frequent basis. So 10% of that salary could be coming from that, and that's okay. But their primary duty is of management. They are doing the scheduling, they are doing the hiring, they are able to give their opinion about hiring and firing. They are the ones that if an issue comes up, they are handling it. They are doing the training. So it's of a manager position, okay? And they have to supervise at least 2 full-time employees on a daily basis. It can be part-time too, but at least 2 full-time employees. For the professional exemption, this one more has to do with advanced knowledge or defined as work which is predominantly in character, intellectual in character, and it includes requiring, consistent exercise of discretion and judgment. So it's an advanced knowledge in a field of science or learning. So these are like your nurses and doctors, and you have to have a degree, right, in the field that you're working in. Teachers, things like that. So they're constantly working in that field of study that they received their degree in. And of course, the salary of $684. Now, there are some workers who, because of the types of jobs that they hold, are exempt or not subject to overtime requirements. So workers who are exempt need not to be paid a premium rate more than time and a half after 40 hours. So some examples of this are over-the-road truckers. We have a 13B1 exemption that would state that they don't have to receive overtime, along with helpers and loaders of the road truckers. Agricultural workers, there are exemptions for them when it comes to overtime. And then certain retail workers who earn most of their money in commissions. You have your automobile salespeople, your partsmen and mechanics, white collar, salaried workers, or outside salespeople, motion picture theater workers. They would all be under where they wouldn't have to be paid overtime. And also, take notice, and someone who's being paid a salary does not necessarily mean a person is exempt from overtime. Okay, we got to look at their duties. We got to ask what they're doing. Just because your title says manager, administrator, doesn't necessarily mean that you're exempt from overtime. Okay. So employment relationship, this is a huge thing when it comes to misclassification. We see a lot of this where we trying to kind of, employers or businesses are trying to, cross that line of what is considered an employee and what is an independent contractor. We see volunteers and trainees. So those kinds of things that all kind of play into this employment relationship. On page 26 of the resource guide, you'll see where it talks about employment relationship. So if you're an actual employee, a worker is entitled to minimum wage and overtime protections under the FLSA. So we can only enforce our laws for those employees that are bona fide employees. Independent contractors, unfortunately, we are not able to enforce our laws for them. There has to be that employment relationship between the worker and his or her employer. Most workers are employees under the FLSA. There are sometimes questions about whether or not an employment relationship exists when an employer classifies a worker as an independent contractor, intern, trainee, or volunteer. So we're more concerned with employers who misclassify workers who are employees under the law. Okay. So the FLSA defines employment very broadly and focuses on the economic realities, there's 7 of them, of the worker's relationship with the employer. Most workers are employees. However, some workers who are employees under the FLSA may be incorrectly classified by their employers as independent contractors, interns, trainees, and volunteers. So misclassification of employees as independent contractors is a particular concern of ours, and we see it every single day. It's more so the employers don't want to pay for insurance or don't want to, have to abide under the Fair Labor Standards Act, so they misclassify these employees as independent contractors. They basically tell them, hey, you have your own business, fill out this form. But in actuality, they are basically telling this person, this is how many hours you're going to work. This is where you're going to be working at. You can't work for anybody else. If an issue arises, this employer has to pay, for the tools and the trades and things like that. So there's 7 items. They are in that resource guide. I'm not going to go into detail about every single one of them because we could be here all night about it. But you do have that document, that resource guide that was able to kind of run you through that. And so that it can get really, really difficult and complicated. So I strongly advise that if you hear independent contractor or, trainee, volunteer, employee, you reach out to us or have that person reach out to us so that we can ask the questions that we need to ask to see if they're actually an employee or if they're an independent contractor. Okay. A lot of times where we see independent contractors is the construction industry. So these contractors, they hire these so-called independent contractors who in reality are employees. We see it with volunteers, we see it with trainees or students, maybe employees under the Fair Labor Standards Act, depending on the circumstances of their activities for the employer. Home workers, so workers who perform work in their own homes, such as sewing garments for a contractor, are often improperly considered independent contractors. And so the FLSA covers home workers, entitling them to all the benefits of the law. Volunteers, we get a lot of questions about volunteers. So individuals may volunteer or donate their services to public agencies or religious, charitable, or similar nonprofit organizations without being considered employees if they do the following. So for public service, religious, or humanitarian objectives, without the promise or receipt of compensation, so being told you're not going to be paid, making sure that you're not going to be paid for the volunteer work that you're doing. They are not employed by the same agency or organization to perform the same services they perform as employees. And in the case of a nonprofit organizations, they typically they don't displace paid employees. So under the FLSA, employees may not volunteer services to for-profit private sector employers. But on the other hand, in the vast majority of circumstances, individuals can volunteer services to public sector employers. So back in 1985, when Congress amended the FLSA, it made it clear that people are allowed to volunteer their services to public agencies with a few conditions. So they may not receive compensation, other than expenses, so reasonable benefits or a nominal fee. They may not be employed by the public agency to perform the same type of services for which they are volunteering. Sorry. I got a tickle. And sorry, there is no prohibition on anyone employed in the private sector from the volunteering in a capacity or line of work in the public sector. Sorry, 1 second. I gotta get this tickle. Okay. I apologize for that. So misclassification, on page 27 of your workbook, you'll be able to see more details about misclassification as an independent contractor or an employee. So this determination is very important because of the FLSA's minimum wage and overtime pay protections applied to covered employees. They do not apply to independent contractors. So like I was talking before, we're only able to enforce our laws if you are an employee. We do not apply our laws for independent contractors. So a hardship of this is employees who are misclassified as independent contractors are often denied, access to critical benefits and protections they are entitled to. So your overtime pay, your minimum wage, the Family and Medical Leave Act, unemployment insurance, and safe workplaces. Those are all things that they are missing out on. So please, if you hear of independent contractors or you're not sure, reach out to us. These are specific questions that we need to ask the employee and make sure that, are you an independent contractor or are you an actual employee? Because you could be missing out on a lot of benefits that the employer should be giving you. So this is, again, an example of this is an employee agrees to work overtime, but be paid straight time in cash, off the books, off the record. because of, perceived tax advantages, or the employer promises more hours, but on the condition that it's all straight time and the employee agrees. So they have this little agreement. They cannot waive their rights to be paid. Under the law, they must be paid minimum wage and overtime. So even though they have an agreement, or they say, okay, yeah, that's fine, I'm okay with that, the law still states what it states, and we can enforce the minimum wage and overtime for that employee. So overtime pay at a rate of not less than 1.5 times an employee's regular rate of pay is generally required for any hours worked in excess of 40 hours. Again, state and local laws may differ. So the FLSA does not limit the number of hours employees 16 years old or older can be required to work in a day or a week. We get that question a lot too. I'm having to work 10 hours a day, or 12 hours a day. We don't enforce anything that has to do with the number of hours. What we enforce is saying you must be compensated for all the hours that you're working, and anything after 40 hours in a work week is to be compensated at time and a half. So for example, if a dishwasher works for $7.50 an hour, she or he must be paid time and a half for every hour worked over 40 in a work week. In this case, the overtime rate is $11.25 per hour, which is $7.50 times 1.5. And each work week stands alone. So work weeks cannot be averaged by any means. We look at each week as is. So 40 hours worked. Vacation, sick, and other paid time not actually worked do not count toward the 40-hour total, because those are not hours worked. Again, overtime is not due after 8 hours in a day, and overtime pay is not necessarily required for work on weekends or holidays. So child labor. This is on page 37 of your resource guide. In the chat group, can someone tell me how old you have to be in order to work?
One response is 16, the age of 16.
Okay. That's close.
Another response
yes.
is 14.
Yes, so 14, you can be 14 years of age and work. And so there are restrictions, however, for 14 and 15-year-olds when it comes to the hours that they can work and the occupations that they can be working in. There are hazardous occupations that are prohibited for anyone under the age of 18. So the Secretary of Labor deems certain things to be very, very dangerous. You have your driving or using certain equipment. I mean, it's absolutely crazy what we see as far as children getting hurt when they're working. So you just have to be very, very careful. Minors 16 or 17 may work unlimited hours in non-hazardous, non-agricultural jobs without violating the FLSA child labor provisions. And so 14 and 15-year-olds can only engage in non-ag employment in certain designated industries and occupations outside of school hours and under certain conditions. 14 and 15-year-olds are prohibited from working in manufacturing, mining, most processing work, and any work in the designated hazardous occupations. In fact, any work not specifically permitted for this age group is prohibited. So exemptions for this are minors of any age may deliver newspapers, perform in radio, TV, movie, or theatrical productions, or gather, this one's an interesting one, or gather evergreen and make evergreen wreaths at home or babysitting on casual basis. Minors of any age may be employed by their parents or legal guardians in their solely owned non-farm business, except minors younger than 18 may not be employed by their parents in hazardous occupations, and minors younger than 16 may not be employed in mining or manufacturing or any hazardous occupations. Okay, so our restrictions for 14 and 15-year-olds. So not during school hours, they can only work 3 hours on a school day. On a non-school day, so the summer, they can work 8 hours on a day. When they are in school, it's 18 hours a week. And when they're not in school, it's 40 hours a week. When they are in school, it is 7 a.m. to 7 p.m., except from June 1st to Labor Day, when the time is extended until 9 p.m. So this is only for 14 and 15-year-olds with the time restrictions. And I will tell you, with the pandemic and the amount of different businesses needing workers, they really focus on kids. Okay, we saw a lot of child labor just this year because the work is needed, right? And these kids that are under the age of 18, they're excited, they want to make their own money, or they want to help their families, right? So we saw child labor violations just skyrocket. Specifically this one, our restrictions, 14 and 15-year-olds, they are very restricted when it comes to the number of hours that they are working. So please talk to your kids, your grandchildren, your nieces and nephews, friends, and ask them those questions. You know, how many hours a week are you working, and what are you doing? So you know, these 14 and 15-year-olds, they may be employed in occupations such as bagging groceries, that's okay, office work, stocking shelves, you know, cashiering. They may work, you know, as a artist or a performer. They are limited when it comes to kitchen work involving the preparation of food and beverages. They may perform only limited cooking duties. So they can cook over an electric or gas grill. They do not involve, that doesn't involve cooking over an open flame. They may cook with a deep fryer that are equipped with and utilize a device that automatically lowers the baskets into the hot grease, oil, but it has to have that button. If they are actually physically lowering that deep fryer, then that is a violation. They may clean cooking equipment and surfaces, filter or transport and dispose of grease as long as the temperature of the surfaces, containers, and grease do not exceed 100 degrees Fahrenheit. And then properly certified 15-year-olds may work as lifeguards and swimming instructors at traditional swimming pools or water amusement parks. So a lot of things, a lot of information. Just please realize we enforce child labor. Ask the questions. If you're not for sure, please reach out to us. We speak with parents. It doesn't necessarily have to be the child themselves, but we can speak to parents or a third party if you see something and you're concerned about it. So, oops, sorry. So, again, page 37 has a lot of resources when it comes to child labor, what they can and can't do, okay? Hazardous occupations, so I kind of touched on this a little bit. This is for anyone under the age of 18. So it's like, you know, those box balers, machine for trash. Kids are just curious. There shouldn't even be a key in it. The manager should have access to that key only, or employees that are over the age of 18. Driving for a company, it can be very dangerous when you're under the age of 18. There's a huge list that employers have to be able to pass in order for anyone under the age of 18 to drive. Your cheese and meat slicers, those are prohibited. The big industrial mixers that you see, sometimes maybe in the grocery stores, in a bakery, places like that, those are prohibited too. Those are just the ones that I can think of that I see on a daily basis in our area. Of course, if you go to other states, you have the whole, you know, mining, manufacturing kind of things. But in this area that I see a lot of, it's your box balers, it's your driving, it's that machinery that's used for baking and cooking. And of course, you know, child labor is a little bit different in agriculture. So this is on page 41 of the resource guide. 16 and older, there's no laws that state, what they can and can't do when you're working in agriculture. 14 and 15-year-olds may perform non-hazardous jobs outside of school. 12 or 13-year-olds may perform non-hazardous jobs outside of school hours at farms where their parent is employed or with parental permission. And there are 11 prohibited hazardous occupations. So children younger than 12 years may be employed outside of school hours with consent of their parents in non-hazardous jobs on a small farm where all employees are exempt from the minimum wage provision. Children of any age may be employed on farms owned or operated by their parents or by a person standing in the place of their parent. On page 45, it goes a little bit into agriculture. So of course we enforce MISPA, H2A, field sanitation requirements. The OSHA field sanitation standards require covered employers to provide toilets, potable drinking water, and hand washing facilities to hand laborers in the field. There are special requirements for H2A workers, including payment of a required wage and minimum guaranteed hours. So it would be in a contract that we would be looking at. The Migrant and Seasonal Agricultural Worker Protection Act, so MISPA, was enacted to protect migrant and seasonal farm workers on matters of pay, work, and work-related conditions. The MISPA also requires farm labor contractors to register with the U.S. Department of Labor and assures necessary protections for migrant and seasonal agricultural workers, agricultural associations, and agricultural employers. For MISPA, it requires farm labor contractors, employers, and agriculture associations to disclose to migrant and seasonal agricultural workers information about their wages, hours, and other working conditions, including housing and transportation, when provided. Workers must be provided with written statements of earnings and deductions. If housing is provided, it must meet the applicable safety and health standards. The vehicles that are used to transport migrant and seasonal ag workers must be safe and properly insured, and drivers of these vehicles must be properly licensed. So when we're looking at H2A, MISPA, any kind of agricultural work, we're looking at contracts, we're looking at payroll, time records, we're looking at making sure that insurance is in place. We're looking at the facilities that are provided to them to live in. Are they livable? Does everything work? So it gets really, really detailed when it comes to our ag laws. In addition to the MISPA, farm workers may also have rights under the Occupational Safety and Health Act, the H2A program, and the Fair Labor Standards Act. So the Occupational Safety and Health Act, field sanitation regulations require covered employers to provide, again, adequate toilets, drinking water, and hand washing facilities in the field. And the H2A program allows employers to hire, temp non-immigrant workers in agriculture and provides worker protection. So lastly, the FLSA may, in certain circumstances, require employers to pay minimum wage and overtime premiums to farm workers. So the Family Medical Leave Act, this is 12 weeks of unpaid leave per year for qualifying reasons. It's job protection, it's protection of benefits and status while on leave, and then you get to return to the same or equivalent position. Now, the eligible airline flight crew employees are entitled to 72 days of FMLA leave, and some military family leave entitlements provide more than the 12 work weeks of leave. So those are going to be the ones that are a little bit different. But you can definitely go through and read the FMLA portion in the workbook. So what qualifies for FMLA? So pregnancy, childbirth and care, adoption, foster care, an employee's own serious health condition, a serious health condition of an employee's spouse, parent, son, or daughter, and then military family leave entitlements. And so coverage applies to the employer and means the provisions of the FMLA apply to that employer. So the FMLA covers all private sector employees who employ 50 or more employees for at least 20 calendar work weeks in the current or preceding calendar year, including joint employers and successors of covered employers. It includes public agencies, which includes state, local, and federal employers, local education agencies, such as public and private elementary and secondary schools. FMLA applies to public agencies and schools, whether public or private, regardless of the number of employees. So with joint employment, a joint employment relationship generally will be considered to exist under FMLA in situations such as, one where there is an arrangement between the employers to share an employee's services or to interchange employees, where one employer acts directly or indirectly in the interest of the other employer in relation to the employee. And the third one is where the employers are not completely disassociated with respect to the employee's employment and may be deemed to share control of the employee directly or indirectly because one employer is controlled by or is under common control with the other employer. And jointly employed employees are counted by both employers in determining employer coverage and employee eligibility. So if you're employed by a covered employer, you worked for the employer for at least 12 months, so 1 year, and you have at least 1,250 hours of service during the 12 months before leave begins, as well as being employed at a work site with 50 or more employees within 75 miles. Again, airline flight crew employees have different hours of service requirement. So eligibility applies to employees and means that the individual employee is entitled to the benefits and protections of the FMLA. So again, they have to work for a covered employer, the 1,250 hours of service during the 12 months prior to the start of their FMLA leave, and again, work at a site that at least 50 employees are employed either at or within a 75-mile radius of that site. The 12 months during which the employee has to have worked for the employer do not have to be consecutive. So periods of employment prior to a break in service of 7 years or more, however, need not be counted in determining the 12 months, except where the break in service is occasioned by the employee's fulfillment of the National Guard or reserve military service obligation or to a written agreement, including a collective bargaining agreement concerning the employer's intention to rehire the employee after the break in service. So break time for nursing mothers. It's a reasonable break time to express milk. Some of the benefits to it is it's a place other than a bathroom that may be used to express milk, and it is for up to 1 year after the child's birth. So those that are eligible for this break time for nursing mothers are employees who work for a covered employer, employees who are covered under an individual basis, so they could be enterprise or individually covered, and employees who are covered by Section 7 of the FLSA. So they are entitled to overtime. When we're talking about coverage, I didn't talk about this at the beginning, but there's enterprise and then there's individual coverage. So enterprise coverage is at least 2 full-time employees or the equivalent, and they have to be grossing at least $500,000 a year in business. And so that would be considered an enterprise coverage. Most businesses are covered under us no matter what, but you will get those smaller businesses that may not meet that 500,000 threshold. And so we're looking at individual coverage. What is that person doing specifically, and are they individually covered? So if some examples of this are if you're running a credit card, if you're crossing state lines on a daily basis, if you're dealing with website, working on an employer's website, or you're answering the phone from people who are coming out of state. So anything that's crossing state lines is enterprise coverage, and that's what we'll be looking at when you're individually covered. And so the compensation for break time. The employer is not required to pay for this break time, but again, if the employee decides, hey, I get this 15-minute break that's compensated for 2 times in a day, then they can choose to take that time to express their breast milk. And they have to be compensated for that time because everyone else is receiving that time as compensable. And then space requirements. Again, it cannot be a bathroom. So a place other than a bathroom. It has to be shielded from view and free from intrusion from coworkers and the public. So simply putting a sign out that says, you know, this room is being used. You can lock the door. So people know what this space is being used for. That's what we mean from free from intrusion from coworkers and the public, you know, closing the blinds, things like that. Those all may be used by an employee to express breast milk. So we do have Section 14C, which deals with workers with disabilities. Section 14C of the FLSA authorizes employers, after receiving a certificate from the Wage and Hour Division, to pay sub-minimum wages. So this is wages less than the federal minimum wage to workers who have a disability that impacts the work they have been asked to perform. The certificate also allows the payment of wages that are less than the, so for like SCA, it's the McNamara-O'Hara Service Contract Act, and the Walsh-Healy Public Contracts Act, PCA, prevailing wage rates. Any employer may apply for a certificate under Section 14C, but they must obtain an authorizing certificate, and we, as the agency that enforces this law, must have that certificate in hand. So we'll be asking for that certificate to make sure that they have been certified in order to pay their employees sub-minimum wage. And so a sub-minimum wage is a key concept under Section 14C. It is a wage rate below the federal minimum wage. It is also a commensurate wage, so one that is based on the worker's productivity when compared to the wages and productivity of an experienced workers without disabilities performing the same work in the vicinity or locality. Employers holding Section 14C certificates can also pay less than the Service Contract Act prevailing wage rate on work subject to the act, but again, only when the workers are disabled for the work being performed. And again, employers must obtain that certificate from the Wage Hour Division before paying sub-minimum wages. Employing a worker with a disability does not in and of itself justify the payment of sub-minimum wages. So a wage rate paid above federal minimum wage or a wage determination or but lower than the state minimum wage is not a sub-minimum wage, okay? So for example, federal minimum wage is $7.25 and the state minimum wage is $8 and the employer pays $7.50. That is not a sub-minimum wage under FLSA 14C. So another concept is, you know, of a worker with a disability. A worker must be disabled for the work being performed in order to be paid sub-minimum wages. The disability alone does not warrant the payment of sub-minimum wages. The disability must impact the productivity of the worker when he or she performs the required work. An employee who uses a wheelchair may have a disability, but that disability may not impact his or her productivity when performing a particular job, such as a receptionist or an accountant. Some disabilities will impact the ability of a person to perform a type of job, but not another. An employee who is visually impaired may conduct business on a telephone without any loss of productivity, but that same individual may be challenged to work as a sorter in a recycling assembly line, sorting donated paper goods. So if you have someone who's being paid sub-minimum wages, I apologize, you might hear my dogs, who's being paid sub-minimum wages, please contact us. Section 14C can get really complicated, and so we need to speak with those individuals. And so the largest number of certificate holders are these community rehab programs. They're called CRPs. These used to be referred to as sheltered workshops. We don't really call them sheltered workshops anymore, but that might be a term that you hear. CRPs are also sometimes referred to as NPAs, so nonprofit agencies, NPOs, nonprofit organizations, or work center. Just because CRPs provide additional services to individuals with disabilities, these individuals may be referred to as consumers or clients. So again, those are all key terms when you're handling people who have disabilities and they're trying to explain the situation. Please refer them back to Wage and Hour. As far as filing a complaint with us, again, we have people who are answering the phones from 8 to 4:30 every single day. And we take complaints via telephone and in writing, so they can come to us in person if they would like. A current or former employee or someone who is familiar with the employment practices of the employer or has a reason to believe a violation has occurred may file a complaint. If you have any questions about whether or not a violation has occurred, please contact us. All services are free and confidential, regardless of immigration status. Please remember that it is unlawful for your employer to terminate your employment or in any other manner discriminate against you for filing a complaint with the Wage Hour Division. So, any employee who believes that his or her employer has violated any of the laws enforced by the WHD may file a complaint. This is true for current and former employees, okay? Our number directly that you can contact us here in the Kansas City office is the 913-551-5721 number, but we also have our national number, which is 1-866-4-US-WAGE that people can call. And again, you may want to have contact information or websites for your local or state labor departments, as those might be different from what we enforce. And this is the website for the Wage and Hour Division. We also have a great youth rules website that talks about child labor. And then we also talk about, all of our laws. You can get it on that website for the dol.gov /e-laws, as well as contact your local office. And that is all I have as far as my presentation. So I'd be happy to answer any questions that people may have or that have